If there is one interruption by you, you will be held in contempt of court. What it is you want to say or not, because
continue commission.
You're interrupting me. Okay, now I'm holding you in contempt. I've given you one chance right now. The court is going to indicate.
This courtroom rebel just found out the hard way that talking over a judge isn't just bad manners. It's practically begging for time behind bars. He tries to represent himself, tosses out some bizarre legal theories, and by the end, the whole hearing spirals into total chaos. And wait until you hear how many days he racks up for contempt. It's way more than you'd think for just arguing. The judge doesn't waste a second shutting it down, but was she laying down the law too firmly or just done with the nonsense? Drop your thoughts in the comments. Now let's dive into this courtroom meltdown.
Thank you. And Mr. Howard Randolph, your name please.
Shadeed Howard Randolph.
Okay, so before we go any further, I'm going to make this statement. I'm going to indicate the last time you were here in court, sir, which was April 20th, there was significant disruption to the court record. So I'm going to state this. If there is one interruption by you with anybody that's talking on the record, whether it be the prosecutor, your attorney, any witness testimony, or the court, you will be held in contempt of court. I just want to make sure you understand that. Do you understand that?
Can you repeat it again? Did I do something wrong? You said I did something wrong.
What I indicated is the last time you were here in court on April 20th, there was a lot of interruptions. Not a disastrous record.
Stop.
We had a disastrous record. So what I'm indicating, so I can make sure that we have a clear record and that I am maintaining order in the courtroom, that there will not be any interruptions by you, whether when the prosecutor is talking, your attorney is talking, any other witness, or myself. If there are any interruptions by you, Mr. Howard Randolph, this court is going to hold you in contempt of court. Do you understand that?
Yes.
And Your Honor, my client understands that I will be speaking for him today, pretty much for the majority of this, for this proceeding. So I don't believe that's going to be an issue. But thank you, and we're well noticed that everyone has to wait their turn to speak. Thank you for the notification. You cannot. Just we're told no interruptions. Just stand there quietly. I will do all the talking. Just interrupted me. That's something you said you were going to do. I'll do it. We're ready to proceed, Your Honor.
Okay, Ms. Ozera, would you like to address the court? If you can step forward, please.
Yes, Your Honor. I am representing Ms. Duff in the custody matter, and with regard to Mr. Howard Randolph potentially being in custody, that was something that we did inform the judge of yesterday, and he said that he would accommodate as necessary if that is the case. I plan to appear as soon as I am back to my computer to inform the judge of the way that these proceedings conclude. I would also like the court to note that while it's been made clear to Mr. Howard Randolph that there is no contact electronically or by other means, that throughout the trial proceedings, Mr. Howard Randolph has continually directly addressed Ms. Duff during these proceedings, which would violate the no contact. And I believe that that will continue to happen. The decorum of Mr. Howard Randolph today might be great, but throughout the Zoom trial has not been great, and he has made threats and has spoken in threatening ways to myself as well as Ms. Duff.
And when you indicate that Mr. Randolph has been addressing Ms. Duff directly, is that during Mr. Randolph's turn to ask questions? Is he representing himself?
He is representing himself. It has not been with regard to any direct examination of Ms. Duff. He has not chosen to, at this point thus far, to question Ms. Duff personally or cross-examine her. This has been in his statements to the court, which then devolved into him directly addressing these stuff.
And Your Honor, we're going to be in the process of getting the transcripts of that particular hearing this week. We don't know the specifics. If the court were not being inclined to reduce further, I would only ask for this one allowance that my client just financed a vehicle. It's in the parking lot. Is no one else to get the vehicle. He asked if I'd be willing to drive to his address. I indicated that it doesn't fall within the things that I'd be willing to do. I asked that my client get a report date later today, if not tomorrow, so he could just take the car back. Because not only is he going to be missing the hearing, he's going to be going into custody. I don't want him to be in a position where his car gets towed and he's going further and further down an avenue that we're just trying to halt and put back into an advantageous position. He understands that if he fails to appear, the consequences are going to be it's going to be a catastrophe. So that would be the only allowance if there would be no bending on any further bond conditions, that he be able to report into custody after taking his car in.
Okay, and I can appreciate that, counsel, but Mr. Randolph can leave his key at the window with the police department, and we can make sure that they're not having it towed, and then his girlfriend can come pick up the key later with the vehicle. I'm not giving him a report date, not at all. I have serious concerns for safety and compliance with this court's order. So the court is indicating 10,000, 10%, no surety, GPS tether in the event bond is posted. You can leave your key with the police department, and then we'll make a note that with what your vehicle is, so that it's not towed and that somebody can pick it up within the next 24 hours or so.
And this is where it all starts to unravel. In a surprising move, the judge actually cuts this guy a break, letting him keep his car from being towed even though he's about to be taken into custody. You'd think that kind of leniency might cool him off, right? Not even close. If you saw his last hearing, you already know. This guy is like a siren, loud, relentless, and impossible to ignore once he gets going. He hasn't even spoken yet, and I'm already mentally preparing for the outburst like it's the finale of a courtroom drama. It's wild how some folks treat court like it's a stage for their personal grievances. This isn't a talk show. It's a legal proceeding. One more outburst, and he's looking at contempt charges, and maybe an extra night in a cell. For now, he's quiet. But trust me, the tension is building.
Well, that's up to me. I got my own mouthpiece. You don't already do what you're gonna do, right?
Sir,
It's okay.
let me just be very clear. Your attorney would advise you whether or not you should or should not address the court based upon what it is you want to say or not, because
Continue commission.
you're interrupting me.
Okay, go ahead.
Because something you say could be used against you. So that is why I indicated if your attorney suggests that you speak.
I'm just saying the Michigan tenure commission needs to hear about this.
Okay, now I'm holding you in contempt. I've already indicated that you are not to interrupt this court, yet you have continued to do so. I've given you one chance. I've given you one chance right now. The court is going to indicate pursuant to MCL 600.1701 that you are engaging in disorderly, contemptuous, insolent behavior during the immediate view of this court and in the court's presence, directly intending to interrupt its proceedings and impair the respect due to its authority. Further, that under MCL 600.1701B, that this court finds you are in contempt during any breach of the peace, noise, or disturbance directly tending to interrupt this court's proceedings. The court will also indicate that this has occurred in the presence of the court. Therefore, the court may punish you summarily by fine or imprisonment or both. Stop interrupting, sir. Therefore, the court's going to...
Honestly, those 15 days feel less like a sentence and more like the judge just needed a break from the constant noise. A legally sanctioned timeout. I mean, sure, he kept interrupting, but that long behind bars feels less like justice and more like courtroom noise control. But what do you think? To me, this one seems more about the energy in the room than the actual offense. And let's be real, after this, he's probably going to act like he just outsmarted the entire legal system, like he dropped some major truth bomb they couldn't handle. In reality, he's one more outburst away from live streaming a holding cell like it's a government expose. The law gives judges a lot of freedom when it comes to contempt. There's no hard limit. She could have gone all the way to 30 days just for the attitude. And in this case, she might have been tempted.
While, sir, you were quiet and not interrupting this court's order nor the proceedings, towards the end of the proceedings, then you began to interrupt this court.
I ain't get
Despite-
spoke my mind.
Despite this court's order not to
Speak my mind.
not to interrupt this court.
I didn't interrupt.
Therefore, as is evidenced still by your continued interruption of these proceedings, the only corrective action necessary to restore order and maintain the dignity and authority of the court is to hold you in criminal contempt and sentence you to 15 days jail.
Okay, but hey, you filed a false police report, you let it get in your courtroom, so did the prosecutor and the team.
Sir.
Commission will hear about it, and it's already, you got
Sir.
a grievance on you already right now.
Sir,
And another
you
one
may
is going
file anything that you
June the
choose.
first, hey, listen,
You
this
may-
domestic violence.
Stop
charge is gonna-
interrupting.
You're gonna
Stop
get sued.
interrupting.
I guarantee that.
Okay, well, at least you're helping the court make a record for yourself, for the court as well, as to why this court found you in criminal contempt. We'll see you next week on the
Rio, I love
17th.
you, baby.
You're not to
That's
address,
okay. I'm addressing the bar though.
Sir.
I'll bet you that.
sir, the court's adding another 10 days on for you addressing the victim in this matter. It's a full 25 days. Off the record.
That line, easily top tier in the worst things to say before sentencing Hall of Fame. If you're hoping for leniency, maybe don't cap it off with a parting shot at the entire justice system. That's not edgy. It's basically fast-tracking yourself to an extended stay in holding. Honestly, the only thing missing was him flipping the table or misquoting the Constitution while trying to sound profound. And that moment with the witness. Not clever, not bold, just plain awkward. Now, I don't know about you, but 25 days feels a bit steep for that outburst. Though I guess the judge wasn't in the mood for any courtroom drama that day. Either way, she had time, and she used every second of it. Let me know what you think in the comments. Was it fair or over the top? Don't forget to like and subscribe if you enjoyed this one. Thanks for watching. Take care.